Good afternoon, everyone. It is now 2:30 p.m. and we are live. Thank you all for joining us for today's presentation. My name is Jaleesa with Legal Aid of North Carolina's Helpline. Today we have Marissa Thomas presenting for us. If you are unfamiliar with the format of this event, Marissa is going to review a PowerPoint presentation. At the end of the presentation, we'll have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or the comments section on Facebook. We'll review all questions put in the chat boxes during that Q&A session at the end. Please remember that this is a public forum and legal aid is not representing you at this time. Marissa will go over this in more detail, but please remember to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Marissa to get us started.
Good afternoon. Good afternoon, everyone. Like she said, my name is Marissa Thomas. I am an attorney with Legal Aid of North Carolina's Helpline, and about 90% of the cases that I do are landlord-tenant issues. And so today I'm going to be presenting Tenant Basics, a Tenant's Rights Listen and Learn. And we're just going to go ahead and jump in. So first, a little bit about Legal Aid of North Carolina. We are a statewide nonprofit law firm that provides free legal services in civil matters to low-income people in order to ensure equal access to justice and to remove legal barriers to economic opportunity. We host listen and learns on a variety of topics, such as child custody, criminal record expungement, Medicaid, simple divorce, SNAP, Social Security, disability, tenant rights, which is what we're here to discuss today, and wills and power of attorneys. So what we're going to talk about today, we're going to kind of break this down into 4 parts. 1, who is a tenant? We're going to discuss what that means. Talk about the evictions process, the repairs and rent abatement. And when I say repairs, I mean when a landlord isn't making repairs and what a tenant can do in those kinds of situations, as well as briefly touch on some things to be aware of when it comes to security deposits. So who is a tenant? A tenant is someone who has a residential lease with the owner of a property. There's no requirement that that lease be in writing, so an oral lease can be valid, but there must be some kind of exchange for someone to be a tenant, whether that's rent or agreeing to make repairs or there has to be some sort of arrangement that the person living there has made with the owner of the property. There are some circumstances where someone living in a hotel or something like an extended stay can be a tenant in some cases. So the eviction process. A landlord has to go through a court process before being able to remove a tenant or the tenant's belongings from a residence. And again, this only applies to someone who is a tenant. So first, before we get there, how does the eviction process start? It usually starts with something called a notice to vacate. And what a notice to vacate is, it's communication from the landlord to the tenant, essentially with the landlord asking the tenant to permanently leave the residence. It can be given in writing, it can be verbal, it can be done electronically. Some rent leases may specify some specific ways. So like if the lease says, all notices have to be given in writing and posted on the tenant's door, that's the way the notice has to be given. The notice usually details the number of days or provides a specific date, like either like 10 days from this notice or on, let's say, April 20th, the tenant must leave. A notice to vacate does not mean the actual court process has started. Usually, a landlord will send a notice to vacate to kind of avoid having to go through that court process, and it gives maybe the landlord and the tenant an opportunity to maybe work things out before going that court route. So what happens when it does go the court route? And so that's what we call summary ejectment. That is North Carolina's fancy way of saying an eviction. Again, summary ejectment, that court process only applies to someone who is a tenant. A tenant will usually receive a summons and complaint. The complaint will detail the basis, so the reason for the eviction, And the summons will detail the date and the time of the court hearing. A tenant may receive these, documents handed directly to them. A tenant may also receive these documents by them being on the door and another copy posted in the mail. Methods of service can be valid. Usually, almost all evictions start in what we call small claims court in front of a magistrate, who is kind of like the judge of small claims court. There are four bases. So there are four reasons that a landlord can choose when it comes to why they want to evict a tenant. One is non-payment of rent, two, holdover, three, breach of lease, four, criminal activity. Um, in the landlord-tenant space, we call these the four boxes of an eviction. They will be found if you look, that complaint that you see, that's a sample of what an actual complaint in summary ejectment looks like in North Carolina. And those four boxes are in that paragraph 3. The landlord is the one who has the burden of proving the basis for the eviction. So if the landlord is saying, someone didn't pay rent, it's supposed to be the landlord's job at the hearing to prove that that tenant didn't pay the rent, if that's the reason for the eviction. So let's walk through all four really quickly here. So first one, non-payment of rent. This is a situation where the rent was late, the landlord made a clear demand for that late rent, and the landlord waited at least 10 days after making that demand for the tenant to pay the amount owed before filing the evictions. This only usually comes up in oral leases or leases without what we call default clauses. And we'll talk about what that means a little later on. In a situation where the basis of the eviction is non-payment of rent, a tenant can pay all amounts due, including court costs, before a final judgment to avoid, a final judgment of eviction. So for a non-payment of rent case, someone can pay all that is due to potentially avoid the final judgment. Holdover. So this is that second box. Give me just a second. Uh, Sorry about that. Okay, so in a holdover situation, first thing to be aware of, a landlord is not required to continue renting to a tenant. So a landlord can choose, like if a lease has ended, a landlord can choose to no longer rent to that tenant for whatever reason. They don't have to even have a reason. Holdover happens when a tenant remains in that residence after the lease has ended and proper notice was given that the lease would be ending. The notice should end the lease at the end of the lease period, which is for, at the end of a year, if it's a year-to-year lease, end of a month-to-month lease, and so forth. If a lease states a specific way that the notice must be given, the notice has to be given in that way. North Carolina does have some minimum notice requirements if the lease does not specify. The minimum requirements for a year-to-year lease is 30 days, 7 days for a month-to-month lease, and 2 days notice for a week-to-week lease. If the landlord accepts rent after lease ends or signs a new lease with that tenant may then have a defense to the holdover eviction. So landlord keeps accepting rent after saying, a tenant had to leave, that tenant might have an argument for against a holdover eviction claim. Okay, breach of lease. This is where a tenant has violated a condition of the lease. This is probably the most common form of eviction out there, is the breach of lease claim. This is where a lease has what we call a right of forfeiture clause. Essentially, it's a clause that says that if a tenant doesn't follow, any rules or these specific rules in this lease, the landlord has the right to terminate the lease and retake possession. Most written leases have a clause like this. Almost all non-payment of rent cases are brought as breach of lease cases. So most evictions for unpaid rent are not brought as non-payment. They're brought as a breach of lease case. Some leases may also waive notice. Some leases might require notice for a breach of lease case. Most tenants in a subsidy program, whether that's public housing, project-based, Section 8, housing choice voucher program, are entitled to a notice. If you are in any of those programs, I would encourage you to reach back out to legal aid and state that you're in one of those subsidy programs if you're experiencing a landlord-tenant issue. Um, the breach also has to be described in the complaint. So at that little box there, you're seeing a copy of that complaint. Right under that number, that paragraph 3, which has our 4 bases, there's a box that says description of breach. Landlord has to actually put a description if they want to evict a tenant for breach of the lease. Last box here is criminal activity. And so what criminal activity is, it's violation of the North Carolina Controlled Substances Act or other criminal activity that threatens the health, safety, or right of peaceful enjoyment. And that can be very broad. A conviction is not required to evict someone for criminal activity. Sometimes the statute can allow for an expedited, so a quicker eviction. Tenants can be held responsible for the actions of other people in their household, as well as guests. So just because you weren't someone wasn't the specific tenant who caused the issue, that tenant can still be held responsible for that act. There can be space for what we call a partial eviction, where only the offending, so only the household member that was involved in the criminal activity is evicted, or a conditional eviction where the guest that was involved in the alleged criminal activity is banned from the property and the tenant gets to stay there. But if the tenant allows that guest to return, then the tenant would be evicted. The criminal activity also has to be described in the complaint. So I'm gonna go back a slide here. And that same box that we talked about where the breach has to be described, if there's criminal activity, that also has to be described there. So this is just a list of some common defenses. This is not exhaustive, meaning this is not every defense that exists. These are just some of the more common ones that we see. If someone is a victim of domestic violence, maybe they're being evicted for criminal activity for having police come out too many times, being a victim of domestic violence can be a defense to an eviction. Waiver, a situation where a landlord has accepted rent after there's been a breach of the lease. If the landlord continues to accept money after that breach and they knew about the breach, that landlord may have waived their right to be able to terminate the lease based on that breach. There's no waiver defense if the eviction is based on criminal activity, as well as waiver defense does not work if there's a valid anti-waiver clause in the lease. And again, a lot of the written leases do have a valid anti-waiver clause. If the notice is invalid, if someone maybe is suffering from some sort of mental or physical disability and the landlord didn't offer them reasonable accommodation, maybe that can be a defense. The amount claimed is wrong. Or especially for criminal activity, if the tenant didn't know or have reason to know that the criminal activity was occurring, the tenant did everything reasonably expected to prevent that criminal activity, that could be a defense to the eviction as well. Again, this list is not exhaustive. When we get further towards the end of the presentation, we'll put a link to our eviction defense manual, which goes through these some of these examples more in depth, as well as present some other potential defenses a tenant may have. Of course, if the court process is started, there is going to be a hearing in court. If you're going to go to court, make sure you show up on time. And by on time, we mean like 15 minutes early. Showing up at the time your hearing is supposed to start is not sufficient. Tenants who have evidence, whether that's pictures, text messages, you're going to want to print those out because a lot of our courts don't allow you to bring your phone in, and try to have 3 copies, one for the tenant, one for the other side, and then one for the magistrate. Tenants can bring witnesses, can object if the landlord is trying to testify to something which the landlord doesn't know about or have personal knowledge of. And magistrates typically rule immediately. That magistrate's ruling is called a judgment. That judgment is not final for 10 days. And so within those 10 days, the tenant or the landlord, if the tenant was the one who won, can appeal the case to district court. There is a filing fee to appeal. A tenant can file a petition to proceed as an indigent or indigency petition for short to seek a waiver of the filing fee. And a tenant who wants to continue to live in that property while waiting for that district court hearing must continue to pay rent. They just pay that rent to the court as something called a rent bond. If the case is appealed, it will be heard in district court, what we call de novo, meaning it will be a brand new hearing. Everybody goes again to present their side. Um, as well as if a tenant does not appeal and pay the rent bond, usually a landlord can get a writ to change the locks on the 11th day after the judgment. And just to be clear, that 10 days, it's 10 calendar days, not 10 business days. And so last kind of thing here about the eviction process is how the written padlocking goes. So if a tenant does not file an appeal of the eviction within the 10-day timeline or fails to timely pay a rent bond, the landlord can then get a writ of possession to have the locks changed. The landlord gets that writ from the clerk of court, and then they send that information to the county sheriff. Sheriff then usually informs the tenant of when the writ will be executed. By executed, we just mean the formal padlocking day, so the day of the actual lockout. That's what it means for a writ to be executed. And when the sheriff does that, the sheriff will come do the lockout. A tenant will have 7 days after the lockout to set up a time to get anything they may have left in the unit after the lockout. Only 5 days. If whatever is left is worth less than $500. So essentially, even after a tenant has been locked out, the tenant doesn't automatically lose their rights to any of their belongings that still may be in the unit after the padlock date. Okay. And so now we're going to move on to our second, I think this might be our third topic here, a landlord's duty to make repairs. Landlords have a duty to keep their units in a fit and habitable condition. What does this mean? Landlords have to obey the local housing code, repair dangerous conditions in a reasonable time, keep common areas safe, keep electrical, plumbing, sanitary, heating, and other facilities and appliances in a good and safe working order, install smoke and carbon monoxide detectors. These duties cannot be waived or avoided by the landlord. A tenant must continue to pay rent unless given permission by the court to withhold rent. So a landlord has to make repairs even if a tenant isn't paying rent, a tenant still has to pay rent unless the court says otherwise, even if a landlord isn't making those required repairs. So then what's the tenant's recourse? That can be what we call rent abatement. So when the landlord fails to uphold their duty, a tenant can first think about calling their local code enforcement for an inspection, or the tenant can also bring a lawsuit against the landlord. That lawsuit is called rent abatement. And what rent abatement is the tenant asking for a portion of the rent that has been paid back because of the poor conditions of the residents. It can also be asking for the rent to be lowered until adequate repairs are made. A tenant can file suit in small claims court, just being aware that there is a cap to how much money can be claimed in small claims court. And if a tenant is looking to, seek more than that, they would need to file in a different court. A tenant can use an indigency petition, so that petition we talked about earlier, to seek a waiver of the filing fee for filing an appeal of an eviction. A tenant can use that same kind of document to avoid the filing fee for filing a rent abatement claim. A rent abatement claim can also be a counterclaim to an eviction based on a tenant's failure to pay rent. Some common types of evidence a tenant wants to have to make a rent abatement claim: copies of their code inspection reports, copies of the request for repairs that the tenant gave to the landlord. It's best tenant wants to have some written dated requests for repairs. So that's text, emails, copies of work orders. Those are kind of some of the best types of evidence a tenant can have. Pictures of the conditions, especially if those pictures have dates on them, and a tenant can show, hey, this was a problem 4 months ago. It's still a problem now. Look at these pictures. It's actually only gotten worse. That can be some great evidence for a tenant can present. Tenants can also provide testimony about their conditions, their knowledge of what's been going on, and what they think the value of the home is. It can cover the tenant, guests, other residents, even the code enforcement inspector. Now, when we're talking about rent abatement damages, we're talking about money. How much money should a tenant be thinking about? So rent abatement is the difference between the rental home as warranted and the actual fair market value because of the poor conditions. What that essentially means, the best way to kind of think about it, is that it's the difference between the rental amount that a tenant's been charged versus how much the home is actually worth, because it's not worth that much because of the poor conditions. Damages are limited to the amount of rent actually paid by or on behalf of the tenant. This might include payments by a subsidy program. A tenant can also ask for what we call consequential damages. And what that means, that's just additional money. Like if a tenant had to spend money on space heaters because there was no heat during winter time, or which, space heaters obviously allowed to can cause increased utility bills, or had to stay at a hotel, just anything paid by the tenant as a result of the landlord's failure to make those repairs. Situation where a tenant breaking the lease. A tenant is bound by the terms of the lease. That lease is a contract, it's an agreement, a tenant is bound by that. This includes any terms regarding early termination of the lease by the tenant. The landlord does not have to agree to allow a tenant to break the lease early. There is an exception if someone is a victim of domestic violence. Um, that victim may be able to break the lease early. That in a situation, that tenant is required to provide the landlord with some specific documentation and a 30-day written notice. The tenant is still, even in that situation, the tenant is still responsible for rent through those 30 days. A tenant who still chooses to break a lease early, even though, the landlord might not agree to that, can still be held responsible for rent through the end of that lease. Now, the landlord does have a duty to do what we call mitigating damages, which essentially means, you know, limiting the amount of money that they can get from that tenant, which ultimately means just finding a new tenant. And the tenant can aid the landlord in finding a tenant, but like the tenant saying, hey, I want this person to take over my lease or rent from you now. The landlord just doesn't have to, just because the tenant presents a capable new tenant, does not mean the landlord has to accept that new person. And last thing that we're going to touch on for just a few moments here before we get into questions is what we call security deposits. A landlord has 30 days after the tenant vacates to return the security deposit or to provide the tenant with an itemized list of the deductions. Normal wear and tear cannot be deducted from the security deposit. A landlord can have up to 60 days to return the deposit as long as they send an initial accounting within the original or first 30 days. Tenants should document the condition of the residence when they vacate. That's take videos, take pictures, um, maybe even do a walkthrough video, recording that walkthrough with someone at the I'm just thinking of a big complex at the main office. Just, as much documentation as the tenant can have about the condition of the home when they vacate it. If the lease fails to identify the bank where the security deposit is held, laws in North Carolina states that a tenant is entitled to a return of the full deposit. Now, some things to be aware when it comes to, some security deposit issues. If a landlord sues a tenant in small claims court and gets money judgment, that security deposit can be used for that judgment. So say a landlord, evicted a tenant for unpaid rent, final judgment was getting the home back and there was a money judgment and the tenant just moved. That security deposit can be used to satisfy that judgment. As well as if the tenant sues a landlord for return of the security deposit and the tenant owes, rent, or the landlord counterclaims, or there's some other money issue at play, a money judgment can ultimately be entered against the tenant. So it's just something for tenants to be thinking about when it comes to wanting to sue for their security deposit back if they have some other outstanding balances with that landlord. So we're going to open it up for questions, but before we do that, and I don't actually see any questions right now on Zoom, but I can't see the Facebook, so I'll ask Jaleesa about that in a second. As Jaleesa said when we got started, while I am an attorney, I am not your attorney. I can only answer general questions in this forum. Our conversation is not protected by attorney-client privilege. There's no attorney-client relationship being created here, but I am more than happy to respond to any general questions as they come in. And I will also be putting a link to our eviction defense manual in the chat right now. So if you have a question, you also can't unmute in this forum, so you need to either type that question in the Q&A box on Zoom or the comment section on Facebook. Jaleesa, are we seeing any questions on Facebook right now?
Right now, I don't see any questions. I will just take a few moments to see if any additional questions come in.
One just came in. Okay. Someone's asking if the PowerPoint will be available. A recording of today's session, Jaleesa will talk about this more in depth, will be available on our Facebook page immediately after the event, and you should be able to look at everything, review the PowerPoint at any time after that. So next question is asking how long does the landlord have to provide, I guess, the notice before requesting to come to or how much notice does the landlord have to give before being able to come to the unit? I think is what that question is asking. And so lease usually kind of describes how much notice, like a 24-hour notice and things of that nature. If it's an emergency, a landlord does not have to give any notice to the tenant. North Carolina law doesn't actually have explicit like requirements like some other states do, like there has to be a 24-hour notice. But a lot of leases do say that information. So in a situation like I would have the tenant review their lease or maybe even work out some sort of agreement with the landlord, like, hey, just give me a 24-hour notice before you come to the unit for anything beforehand. That's just something the tenant can work out. I think that was what that question was asking. Let's see if anything else comes in. Yes, okay, perfect. All right, gonna give it just a second here. See if anything else comes in. So I'm not seeing any other questions, so I'm gonna let Jaleesa go. Oh, yep, gonna let Jaleesa go ahead and close this out.
Okay, so thank you all for joining us, and special thanks to Marissa for presenting. If you would like to review anything that we talked about today, we have posted the recording of today's event to our Facebook. It will be immediately available. You can access this with or without a Facebook account at www.facebook.com/legalaidnc. If you would like to register for one of our other Listen and Learn presentations, such as expunction, Medicaid, and Social Security, you can do so on our website, legalaidnc.org/clinics. Have a great day, everyone.